There are some stories that begin not with a shout, or a chase, or a mystery in the dark, but with a quiet house. A house where 2 cups may still be near the sink. A house where photographs remember decades more clearly than the people living inside it can bear to speak aloud. A house where the ordinary rhythm of marriage has gone on for so long that it has become almost invisible. Morning tea, familiar footsteps, a coat hung in the same place, a chair by the window, a voice from the next room. And then, one winter morning, that rhythm stops. At first, what happened inside the home seemed simple to some, and impossible to others. 2 elderly people had made a decision together. One of them died. One of them lived. And because one lived, the law had questions. The police had questions. A courtroom would later have questions too. But beneath every question was something older and quieter than the machinery of justice. What does love look like after nearly 60 years? What does choice mean when illness has taken away so many other choices? And when a final act is done in a private room, between 2 people who know each other better than anyone else ever could, who has the right to define it? This is not a story of a stranger in the night. It is not a story of greed, rage, or a hidden enemy. It is a story about a marriage, an illness, a promise, and the thin, difficult line between compassion and crime. For a long time, the people at the center of it lived quietly. They were parents, grandparents, neighbors, a husband and wife who had built a life in England's Midlands through work, family, hardship, and the ordinary passing of years. Then illness entered the house. And after illness came fear. After fear came a plan. And after the plan came a trial. Tonight, we will move slowly through that story. We will stay close to what is documented. We will not rush the ending. And we will remember that before this became a case, before it became a headline, before it became a legal argument. It was a human life shared by 2 people who had already spent almost all of their years together. Welcome to this calm, true crime story for sleep. This episode is told in a slow, steady style, with no graphic detail and no sudden sounds. It is intended for nighttime listening, quiet reflection, or black screen viewing. Tonight's case concerns Mavis and Dennis Eccleston, a married couple from Staffordshire, whose private decision became a public legal case. Dennis was terminally ill. Mavis survived what prosecutors would later examine as a suspected unlawful killing. A jury would eventually decide whether the evidence showed murder, manslaughter, or something else entirely. As always, the aim here is not to sensationalize pain, but to understand the documented facts with care. So, settle in, lower the lights if you are able, and let the story unfold at an unhurried pace. Before there was a court case, there was a marriage. Mavis and Dennis Eccleston had been married for almost 60 years. That length of a time is difficult to imagine all at once. It is not one memory, but thousands. It is the early years of making do. It is bringing up children. It is the particular silence that grows comfortable between 2 people who do not always need words. Dennis Eccleston had worked as a miner. He came from Staffordshire, an area where mining was not just a job for many families, but part of the local character. It shaped routines, bodies, friendships, and the quiet pride of working people. By the time the events of this case unfolded, Dennis was an elderly man. Mavis was elderly too. They were not beginning their life together. They were near the far end of it. Their children were grown. Their family had expanded. And like many couples of their generation, much of their life existed beyond the public record. The things that mattered most were not in court documents or news reports. They were in private rooms, in small acts of care, in the countless ordinary gestures that make up a long marriage. But in 2015, Dennis received news that changed the shape of his remaining years. He was diagnosed with bowel cancer. According to public case summaries, he was 79 at the time of that diagnosis. And the illness was terminal. Terminal illness has a way of changing time. Days become measured differently. Appointments take on new weight. Ordinary pain becomes a message. Family conversations become more careful. Hope does not disappear. Exactly. But it changes form. For some people, hope is more treatment. For others, hope is comfort. For others still, hope is the ability to decide what the end of life will look like. Dennis, according to later reporting, did not want treatment. ITV reported that Mavis later recalled Dennis saying he wanted to die in his own way, and that the couple discussed traveling to Dignitas in Switzerland, a clinic associated with assisted dying. These are difficult matters, and in the United Kingdom, they sit within a complicated legal and moral landscape. Assisted dying has long been debated in Britain. Supporters often speak of autonomy, dignity, and relief from suffering. Opponents often speak of protecting vulnerable people, the sanctity of life, and the dangers of pressure, even when pressure is subtle or unintended. But Mavis and Dennis were not lawmakers. They were a married couple facing the reality of Dennis's illness at home. To people outside the relationship, their conversations could later be examined, challenged, and interpreted. But inside the marriage, the conversations were likely quieter, more intimate, and more painful. It is one thing to speak about illness in general. It is another thing to sit across from the person you have loved for nearly 6 decades and hear them say they do not want to continue. It is another thing still to decide what you will do with that knowledge. The documented accounts say that Mavis and Dennis made a plan to end their lives together in February 2018. The word "together" matters here. This was not, according to Mavis's account and the defense position, a case where one person secretly acted against the wishes of another. It was presented by the defense as a joint decision, made by a couple who both understood what they were doing. The prosecution, however, raised a different question. Did Dennis truly know what he was taking? Was he fully aware that the medication could be fatal? Had Mavis assisted him in a way that crossed the line into unlawful killing? Those questions would eventually reach a courtroom. But before the courtroom, there was the bedroom, the ambulance, the hospital, and the terrible fact that one of them survived. In February 2018, Dennis and Mavis Eccleston were at home. Dennis was in the late stage of a terminal illness. The couple had been living with the knowledge of his diagnosis for years. By then, his disease was not an abstract possibility. It was present. It shaped the household. It shaped what Dennis could imagine for himself. The couple took medication in what has been described in reports as a joint suicide pact. The exact private moments are not fully knowable, and they should not be embellished. What is known is enough. They both took substances intended to end their lives. Dennis did not die immediately at home. He was taken to hospital. Mavis was also taken to hospital and received treatment. Dennis died 2 days later. Mavis survived. That survival changed everything. Had both died, the story may have remained private, held only by grief-stricken family and a brief official record. Had neither died, perhaps there would have been a medical and safeguarding investigation, but not the same kind of criminal proceeding. But Dennis died, and Mavis lived. And when one person dies after another person is believed to have helped provide or administer fatal medication, the law does not simply look away. The authorities had to ask what had happened. They had to ask whether Dennis had made a free and informed decision. They had to ask whether Mavis had helped him die. They had to ask whether helping him die, if that was what occurred, amounted to murder, manslaughter, or no crime at all. This is where the language of love and the language of law begin to diverge. A family might say, "She loved him." A prosecutor might say, "What did she do?" A spouse might say, "I could not let him suffer." A court must ask, was the act unlawful? None of those questions is simple. None of them erases the others. In the aftermath, Mavis was arrested on suspicion of murder. ITV later reported that this happened within hours of her being resuscitated in hospital. Imagine that transition. One moment, she was a wife who had expected not to wake up. The next, she was alive, medically treated, and facing the possibility that the final act she believed she had shared with her husband might be understood by the state as homicide. She was not a young defendant. She was around 80 years old. She had just lost the man she had spent almost 60 years with. And now, instead of grieving in private, she was drawn into the slow and formal world of criminal justice. The prosecution case would later argue that Dennis may not have been aware he was taking a potentially lethal overdose. The Independent reported that prosecutors alleged Dennis was unaware and that Mavis had made admissions to 2 mental health nurses. Mavis denied murder and manslaughter, and her account was that both she and Dennis were of sound mind and had agreed to take medication together. In many true crime stories, the central conflict is between what happened and who did it. Here, the central conflict was different. There was little dispute that medication had been taken. There was little dispute that Dennis died. The deeper question was consent. The deeper question was intention. The deeper question was whether Mavis's actions were criminal, compassionate, or both under a law that could not easily hold the full emotional reality of the situation. When investigators began looking into Dennis Eccleston's death, they were not entering a conventional murder inquiry. There was no hidden body, no fleeing suspect, no public danger. The person under suspicion was Dennis's elderly wife, a woman who had also taken medication and nearly died. But criminal investigations are not guided only by appearances. They are guided by evidence, statements, medical records, and legal standards. Investigators had to reconstruct a private plan made between husband and wife. They had to look at who obtained medication. They had to examine who took what. They had to listen to Mavis's statements. They had to consider Dennis's medical condition and mental capacity. And they had to decide whether there was enough evidence to put Mavis before a jury. Eventually, Mavis Eccleston was charged with murder and manslaughter. The trial took place at Stafford Crown Court in September 2019. Public summaries state that after the trial, the jury found Mavis not guilty of both murder and manslaughter on Wednesday, September 18th, 2019. A courtroom can be a cold place for intimate grief. Everything must be translated. A marriage becomes evidence. A conversation becomes testimony. A final decision becomes something to be tested under cross-examination. For the prosecution, the question was whether Dennis had truly known what he was taking and whether Mavis's role caused his death unlawfully. For the defense, the story was one of mutual agreement, sound mind, and a couple acting together after years of marriage and serious illness. The jury had to listen to the evidence and decide whether the prosecutions had proved its case beyond reasonable doubt. That standard matters. A person may have done something morally complex. A person may have acted in a way that troubles the law. But in a criminal court, suspicion is not enough. Sympathy is not enough. Discomfort is not enough. The evidence must meet the legal burden. In Mavis's case, it did not. The jury acquitted her of murder. They acquitted her of manslaughter. She left court legally cleared. But legal clearance does not undo what has happened. It does not bring Dennis back. It does not erase the months of fear before trial. It does not give the family back the privacy of grief. Outside court, one of the couple's children, Joy Munns, spoke about the ordeal. In a statement reported by Dignity in Dying, she said the family was grateful and relieved that the jury had recognized Mavis's love for Dennis, and described the family's fear that after losing Dennis to cancer, they might also see Mavis imprisoned. That statement holds the emotional center of the case. For the family, the trial was not an abstract test of public policy. It was their mother in the dock. It was their father gone. It was 18 months of uncertainty after a death that had already left them grieving. And yet, for the legal system, the case raised a serious issue. If one person helps another die, even out of love, what should the state do? Should the law distinguish between malice and mercy? If so, how? And how can vulnerable people be protected while also respecting the choices of those who are terminally ill? The Mavis Eccleston case did not settle those questions. It gave them a human face. After her acquittal, Mavis spoke publicly. ITV reported in January 2020 that she said she had no regrets and would do the same again, while also saying Dennis would never have asked for her help had he known the ordeal she would later face. That is a haunting thought. A man who wanted control over his own death may have wanted to spare his wife from suffering. Instead, the final act they planned together, left her not only widowed, but accused. That is one of the quiet tragedies of the case. Not only that Dennis died, not only that Mavis survived, but that the act meant to end suffering opened a different kind of suffering. One measured not in pain charts, but in interviews, charges, hearings, and headlines. To understand why this case became so difficult, it helps to slow down and look at the difference between assisted suicide, murder, and manslaughter in broad terms. In England and Wales, suicide itself is not a crime, but assisting another person's suicide can be a criminal offense. Murder, meanwhile, requires proof of an unlawful killing with the required intent. Manslaughter can apply in other forms of unlawful killing. The legal system therefore had to examine not just the emotional facts, but the mechanics of what happened. Did Dennis decide freely? Did he administer the medication himself? Did Mavis do something that legally caused his death? Did she intend to kill him? Or did she intend to accompany him in a shared act? These distinctions can feel painfully technical when the facts involve a dying husband and his elderly wife. But the law lives in distinctions. A slight difference in action can change a charge. A slight difference in intention can change a verdict. A statement made in distress can become central to the prosecution case. A memory, especially after trauma and medical intervention, can be challenged. The jury's work was not to decide whether the situation was sad. Everyone could see that it was. Their work was to decide whether the prosecution had proved that Mavis was guilty of a criminal offense by acquitting her of both murder and manslaughter. The jury answered no. But the acquittal did not mean the case became simple. For campaigners who support assisted dying, Mavis's case became an example of what they view as a cruel uncertainty in the law. Dignity in Dying described the case as one involving a terminally ill man, a joint attempt to end life, and a surviving spouse facing prosecution before being cleared. For those concerned about legalizing assisted dying, cases like this can raise the opposite concern, that the most vulnerable people must be protected from pressure, misunderstanding, or irreversible acts during moments of despair. Both sides may look at the same case and see different warnings. One sees a loving wife put through prosecution after honoring her husband's wishes. Another sees why the state must investigate deaths involving assistance, even when the emotional circumstances are deeply sympathetic. The difficult truth is that both concerns can exist at the same time. The law can be too blunt for intimate suffering, and suffering can be too complex for the law to ignore. This case was resolved in court, so it is not an unsolved case. But it remains unsettled in another sense. It remains unsettled because it sits at the edge of questions that society has not fully answered. What should happen when a terminally ill person wants to decide the timing of their own death? What should happen when a spouse helps? Should the law punish the act, investigate the act, tolerate the act, or create a regulated pathway where the facts can be known before, rather than argued after? Mavis and Dennis Eccleston did not become public figures because they sought attention. They became public because a private end-of-life decision collided with criminal law. Their story asks listeners to sit with discomfort. It asks us not to reach too quickly for a simple label. Because words like murder, mercy, suicide pact, and assisted dying each carry a different moral atmosphere. The prosecution had its legal theory. The defense had its account of love and mutual intent. The jury had the evidence. The family had grief. Dennis had his illness. Mavis had survival. And the public had a case that seemed to ask whether the law could make room for compassion without losing its duty to protect. There is another quiet layer here, too. Old age can make people invisible. Illness can make them more invisible still. When a case like this reaches the news, the people involved can become symbols. Mavis becomes a symbol of a campaign. Dennis becomes a symbol of a terminally ill person seeking control. Their marriage becomes a symbol of devotion. But symbols are simpler than people. Mavis was not only a defendant. Dennis was not only a patient. They were a married couple with children. Memories, disagreements, routines, and a private language built across decades. The public record can tell us the charges, the verdict, the diagnosis, and the dates. It cannot fully tell us what it felt like inside that house. It cannot tell us the tone of Dennis's voice when he spoke about treatment. It cannot tell us how many nights Mavis lay awake beside him. It cannot tell us what silence passed between them when they understood that the future they had expected together was narrowing. And because we cannot know those things, we should be careful. Careful with judgment, careful with certainty. Careful not to turn human suffering into entertainment. This is still true crime, because the state alleged a crime had occurred. But it is also a story about the limits of true crime. There is no villain hiding behind the curtains. There is no final twist that makes grief tidy. There is only a question that becomes heavier the longer it is held. What should love be allowed to do? On September 18th, 2019, Mavis Eccleston was found not guilty. Not guilty of murder. Not guilty of manslaughter. The words mattered. They meant she would not go to prison for Dennis's death. They meant a jury had not accepted that the prosecution had proved its case. They meant that, at least in the eyes of the criminal court, Mavis was free to leave. But freedom after a case like this is not the same as peace. Mavis still had to live without Dennis. She still had to live with the memory of the plan they made. She still had to live with the knowledge that she survived it. And she still had to carry the public attention that followed. In January 2020, when she spoke to ITV, she said she had no regrets. But she also reflected that Dennis would not have asked for help if he had known what would happen to her afterward. That single thought lingers. Because the story of Mavis and Dennis Eccleston is not only about death, it is about aftermath. It is about what remains when one person leaves and the other must answer for both of them. It is about the gap between a private promise and a public charge. It is about the way love, when placed under legal light, can look different from every angle. For some, Mavis's acquittal brought relief. For others, the case remained part of a larger debate about assisted dying and the responsibilities of the state. For the family, It was the end of a trial, but not the end of grief. And for Dennis, whose illness brought him to that final decision, the story remains filtered through others, through testimony, through reporting, through the words of the woman who loved him, through the verdict of 12 people asked to decide what the law could prove. There is no need to make the ending louder than it is. A man died. A woman survived. A jury acquitted her. And somewhere beneath all of that is the long, quiet history of a marriage. Nearly 60 years, a lifetime of mornings, a winter day, a decision made together, according to the woman left behind, a courtroom asking whether love had crossed into crime, and a verdict that said, in law, it had not been proved. When we tell stories like this, we should do so gently, because the people in them were real. Their pain was real. Their family's fear was real. And the questions they left behind are still with us, not as a sudden sound in the dark, but as something softer, a question at the bedside, a question in the law books, a question in the quiet places where love and suffering meet. What does it mean to stay with someone until the end? And what happens when staying becomes, in the eyes of the law, something that must be judged? Thank you for listening to this calm, true crime story for sleep. Tonight's episode followed the documented case of Mavis and Dennis Eccleston, a husband and wife whose final private decision became a public criminal trial. May we remember them not as headlines, but as people, and may we carry the story quietly, with care. Rest well, and good night.